commercial real estate, finance, mergers, and acquisitions. Next, we have Remy Donnelly, who's a partner with Jones Walker in New Orleans. Remy advises and represents clients in commercial finance transactions, commercial real estate acquisitions and sales, commercial contracts, commercial lease transactions for office buildings and shopping centers, ground leases, and industrial sites. Next, we have Michael Dodson, who's an attorney with Fishman Haygood in New Orleans, where he focuses on a multitude of matters, including real estate litigation. Mike also has extensive experience in handling arbitrations, mediations, and appeals. Next, we have Chad Morrow, who's a member of the Shear Gardner firm in New Orleans. Chad represents clients in the areas of secured financing transactions, real estate transactions, real property, leasing, and other commercial transactions, and who had the pleasure of being my law school classmate. So with that, we will start in on the scenarios and let them take it away. So Amy, can we go to the first scenario, please? Okay, so this is scenario one, where a broker completes a lease with a landlord and is paid upfront on the initial term. The broker has in the lease that he is to be paid on all options renewals with no verbiage stating the broker has to be actively involved in the option negotiation. The option period begins and the owner does not want to pay the commissions as he feels the broker was not involved on the option negotiation. Broker tells the owner that the option terms were negotiated up front when the initial lease was signed. And from here, we'll let our attorneys discuss this situation from what they would do from a drafting standpoint and once the issue arose. Myself.
Hi, I'll go first, I guess. You know, and Kim hit the nail on the head when she said, you know, trying to do your best to sort of solve problems on the front end. And one of the themes I think you'll hear is that as lawyers is to try to anticipate bad scenario and try to provide for how that's going to be handled down the road. That's not always easy, but we try. You know, in looking at this scenario, when it says there is, quote, no verbiage stating that the broker has to be actively involved in the option negotiations, you know, does that mean the agreement says that the broker doesn't have to be actively involved, or is it silent? And I think if it's silent, I think that's the issue, right? You need to be very clear that the option commission is due when the option is exercised without there being any requirement on the part to pay in the negotiations, because that's already been done. The option term was negotiated up front when the lease was signed. The fact that later the broker was not integral in that part of it, but you know, just to tie up all the loose ends, you know, consider an express statement further activity or involvement at all is required for that option commission to be payable.
Chad, we kind of had to break in and out, but I think they got that. Michael, Remy, Julie, any input on the front end?
Yeah, I'll add to what Chad was saying. I'll just personally, this is my personal practice opinion. I am not one that likes to allow these provisions to be in leases that I'm negotiating for clients, just because, you know, that agreement is between, you know, the landlord and the tenant, and we're, you know, I was circulating this information before. I mean, this to me rises to a third-party beneficiary, right? For someone who is not signing the contract, for someone, you know, who's expecting something to come out of something in the future, and especially with respect to options and renewals, that, you know, the circumstances change. I'm getting some feedback. I don't know if it's me or something else. Hello?
Unmute. Yeah, I just muted them. If we could just get everybody muted right now while they're talking, and then we will unmute everybody at the conclusion of their remarks so y'all can ask questions. How about that?
Yeah, and so I'll just finish up real quick. So, my preference is always to tell brokers and agents, hey, listen, have your agreements in very good defined commission agreements with the party you're expected to receive payment from. Get that in writing, in a document that with your counsel or, with your firm that you feel comfortable is enforceable, and get that versus having it in a document of which you are not a party. And so, because one thing I confront this issue when I'm up against a renewal or an option, and even if there is not a provision with respect to a commission being paid, and someone's like, oh, well, the prior broker worked them. Do we need to call them and get them involved? And, my answer is like, you involve whoever you want. And the reason is, what if we don't renew the lease in accordance with these options in the actual lease agreement, and we decide to do a whole new lease agreement? And so what's the difference, even if that was a whole new tenant? So for me, I don't feel like it's the best place for the commissions to be. And so I would always recommend, on transaction, brokers to go, again, get their agreement. If it's the landlord, obviously mostly paying the commission, get your agreement in writing, even if you're on a tenant side, with that landlord to stipulate, hey, I'm getting paid this regardless, and you're acknowledging it, and these are going to be my payments. And also on options and renewals, if it's renewed in accordance with the terms of this lease, I will be paid a commission if we're exercised in accordance with that renewal. Because, as you know, I think the big issue is a lot of options and renewals will just bring up an opportunity for a renegotiation. And many times we're renegotiating these leases well in advance of these options and renewals happening. So you're really not extending a lease most times in accordance with a pre-negotiated renewal or option, right?
Great, Remy. And I don't know if Julie or Michael wants to touch on this. One thing we talked about, which I think is the general practice, but if it's not, it's something y'all all want to consider, is doing a separate lease agreement and a commission agreement, and referencing the commission agreement in the lease agreement. So if someone wants to touch on that.
Yeah, I agree, Kim, with what you are saying and with what Remy and Chad have said. I think best practice is to have a separate commission agreement or listing agreement, whatever it's called. But the point is to be clear of what is owed by the owner to the broker. And in this scenario, I think that the broker has a good argument that the commission is owed on the renewal because there's nothing stating that the broker had to be involved. I think it'd be better to be more clear on the front end and be clear that the broker does not have to be involved, to expressly say that in order to be entitled to the commission.
And Kim, I think you're on mute.
Oh, Michael, what about from a litigation standpoint? So say this wasn't able to be worked out and it gets to you.
Sure. So I think the big concept that I wanted to touch on with this one, and Remy made passing reference to it, and that's the idea of a third-party beneficiary role. Louisiana has a principle of law that where two parties agree to a benefit for a third party who's not a signatory to an agreement, that makes that third party a third-party beneficiary. And so in that situation, you'd have a lease between the landlord and the tenant, and it would stipulate a commission owed to the broker, so the broker can actually go in and enforce that. As Remy, Chad, and Julie have all said, it's cleaner to have a separate standalone commission agreement, certainly best practices. But in the event that there isn't a commission agreement and you're only looking at a lease where there's this benefit, this commission stipulated for you, you can still go into court and seek to enforce that agreement.
Okay, Remy, what's that fancy Latin word for that?
The stipulation por tree, if I say that right. And I actually circulated, I'm sorry, I just want actually circulated a case before this call that a broker recently prevailed at the First Circuit Court of Appeals on this exact, I mean, not in a lease context, but in a purchase agreement context, which I was actually kind of surprised that they won on that one, because it was a defaulted sale and there was an agreement to pay the commission regardless. And the broker in that case wanted the trial court and had the decision confirmed that on summary judgment that the commission had to be paid. So to Michael's point, it's not all is ended, but it's the cost to litigate it could be prohibitive.
Okay. Well, how about this? If anybody has any questions on this one, so Amy, why don't we unmute everybody and just see, and if not, we'll move on to the next one.
So I would say if you do have a question specific to this scenario, unmute yourself to be able to ask it. If not, we can move on to the next scenario. I think y'all are good.
Okay, then we'll move on to scenario 2. And before I do that, I just see a question. What's the number for the legal hotline? Let me it's not a hotline in a sense that you can call and get an answer. So we might need to rename it. It's more like a broker reach out line. It's all online.
I'll put a link to it in the chat box.
Okay, so, all right. So scenario 2, broker leases space to tenant. Lease states that landlord will pay all commissions for renewals. Landlord sells building and assigns lease to the buyer. Renewal for tenant comes up and new owner says he does not owe a commission to the broker for the tenant who wants to renew. Is the successor landlord obligated to pay renewal commission to the original broker responsible for the presence of an existing tenant who renewed? And whoever wants to jump in on that one, Julie, you want to start us off on this one?
Sure. So I think here in a typical situation like this, the assignment of the lease would include an assignment and assumption where the new owner, landlord, the assignee, assumes the rights and obligations of the prior owner, assignor of the lease. And in that would assume, among other obligations, the obligation to pay the broker's commission. So I think that the new landlord does owe the broker commission in this scenario. Now, whether the broker could go after the prior landlord, I think it would depend on the language. There could have been a release of the prior landlord, there may have not been, but I think the first step would be to go after the new landlord.
Chad, Remy, Michael, anything to add?
I completely, with all of what Julie just said. I mean, I think one, you'll see a lot of provisions in leases where tenants agree that the landlord with the respective landlord will be fully released, meaning the current owner upon an assignment, provided that the new owner fully assumes the obligations of that lease. So you may no longer have recourse against the actual landlord owner that you contracted with or had the provision in the lease with. And then, if the assignment is in writing and they do assume these, all, which I wouldn't suspect in most transactions, that I've worked on, any outgoing owner would want to be relieved of those obligations and would make the new incoming owner assume it. So you would have recourse against that new owner. I'm sure they will present all kind of legal arguments, just as I'm sure anyone on this call we would take any cut to protect our client. That's just the legal business. But I think the law supports enforcing it against the new owner.
Okay, Chad?
I think all that is correct. The original landlord will likely not have gotten the benefit of this option renewal, so it doesn't really make sense to make them liable and hold them liable for the. Of course, get sued with everybody. You sue all the parties that you can. Won't have gotten the benefit of the option. They're not.
Right.
Still the landlord, and they probably didn't get the benefit of the option because more likely than not, that option renewal wasn't factored into the underwriting of the purchase price. They didn't get that front end and certainly aren't getting it now. So I don't think that original landlord thinks they're still going to be bound for the commission. And I think Julie and Remy are exactly right that the buyer entity, the new landlord, is responsible now. They're getting the benefit of having that option rent in place, so they should bear the price of that and pay the commission.
Okay, Michael, anything to add?
No, I agree with everything they just said. So I think
Okay.
they've covered it.
Great. Well, Matt, is Matt Eaton on the line? This was a very simplified version of a scenario Matt found himself in and his office in. Amy, would you mind unmuting Matt for a minute? And if he wants to kind of give more details about his situation, and maybe we could have the attorneys on the line kind of touch on that. I know I'm throwing y'all a curveball.
Go ahead, Matt.
Hey, I'm here. Can y'all hear me?
Yes.
Okay, great. Yeah, this was an interesting case that we had that where the owner of the building did a master lease to his son, who in turn took over a lease that we put in there before, and yeah, just a lot of moving parts here, but basically option came up, and the agreement we had with the father, he was saying no, he doesn't owe anything, and that you know, this master lease came in, and so nobody owes the commission. And what happened there was apparently they changed one section in the option term to it. So they said that they get 2 reserved parking spaces, which changed the entire terms of the lease. So the options, due to that, it was just, yeah, we lost the case basically because they changed one little term there. If any of that makes sense. Sorry, I was thrown off a little bit, Kim, with, but yeah.
Got your toes there.
Yeah.
Anybody have anything they could weigh in on that? Does that make sense to y'all? What happened in that particular case was the lower court found in favor of the broker. It went up to the appellate court with not really enough detail and facts for the appellate court, so they overturned the lower court. And I think y'all just made a business decision that it was not worth pursuing it. And we did look at it in terms of legal, the legal defense fund and doing an amicus, but we found that because the facts were limited and it was a very specific situation, that it probably would not have that much of an impact because the scenario was unlikely to happen again. And if it did, there were ways that in the front end, they could have prevented that.
It doesn't sound like a fair outcome, but without knowing the facts better, it's hard to comment on further.
Right. I think I've read the case from the Fourth Circuit. It was an opinion from the Fourth Circuit on it. And I think that, you know, there were 2 interesting aspects to it. One was this idea about the terms and conditions having been changed with respect to this parking spot. But also separately, I believe that the master tenant was somehow very closely related to the original landlord or something like that. And so what ultimately was the opinion in the Fourth Circuit was ultimately that there was no privity vis-a-vis the new master tenant that would have been the sublessor. And then, so they didn't do a straight breach of contract analysis. And privity is meaning there's 2 people who are signatories to the contract. And then the next question is whether there were any allegations of improper conduct such that there was circumvention of the original deal. And the Fourth Circuit said that that wasn't adequately alleged. So ultimately that case, I believe, rose and fell on the original pleading. And as Julie said, I mean, the question is whether that's really a fair result, but the court applied a pretty strict pleading analysis.
Right. And from Louisiana Realtors perspective, not that I don't know what the executive committee and the board would have done, But that's something that maybe we would have wanted to do an amicus early on or an amicus at the appellate level. But if, you know, if you'll come to us early, it's always easier, just as if you bring your attorney in early, it's easier too. It's hard for us to, you know, do something when we have 2 days to do it. And you always need to have your own attorney to give you legal advice and make business decisions, because that's not LR's role, but we do have resources available. So unless anybody has any questions about this scenario, we'll move on to the next one.
I have a quick question.
Okay.
What is there anything that we could do as brokers if we are representing the buyer in that scenario, and would thus then become the leasing agent to prevent a commission on a renewal to an agent who was the leasing agent in the past but is no longer involved?
I mean, I'll take it. I mean, I think that's, you'd have to contract that away at you know, the closing of the transaction. You would, you know, obviously do your diligence, go through these documents, see what the residual obligations are, and have to kind of contract that out of the deal. I mean, that would be me. The only way I would see to address it. You know, others may have a different take or you know, way to do it, but I think to me, it definitely would say, okay, this is a liability that we don't want to assume. We're going to contract away in our purchase agreement with this seller that they're going to retain it. We'll probably have some residual paper that further memorializes that, you know, post closing. So when this comes up, that they would be responsible for it, or you know, you're making a concession in price as a result of it, you know, at the closing.
Okay. Does anybody else want to weigh in? And Clint, does that Clinton, does that answer your question or help somewhat?
Yes. Yeah, definitely.
Okay, great. Okay. Anybody else? No, quiet today. All right. If not, Amy, let's go ahead and move to 3. All right. So broker lists property which states commission is paid 50% upfront and 50% on the first anniversary of the initial term. The landlord pays the first half of the commission to the broker, but upon anniversary payment, the anniversary of payment, says he's heard tenant is not doing well and they want a rent reduction, so he should not have to pay the second half of the commission. Tenant is still in the building, but broker is not privy to the new rent payment if there was one. Owner is not responding to broker's request that he be paid. So who wants to take this one?
I'm happy to go. I mean, this one, I mean, this may be redundant of some of the things we're saying here, but it's a little hard to answer this one in full without knowing the exact terms of the commission agreement, of how this thing was stated. I mean, if we're talking about we were going to be paid 50% of, you know, all rent, you know, actually paid. And I think this goes back to being very ironclad in the terms of your commission agreement, to where you're really speaking to these things, that this is the fee, you know, regardless of the circumstances, you know, following out of here, I'm going to be paid, you know, X and Y on these specific dates, regardless of your actions. I mean, I negotiated this transaction. This is the fee that I earned for it. And, you know, if you all are, you know, doing transactions that are changing the rental structure, then, you know, that's your, you know, your prerogative. So I think that would be one, the terms of that. And, you know, some from the litigation side, like Michael may say, there's other things you can start to put in motion legally by asserting some of your legal rights and privileges, as far as, you know, having a potential open account claim, and then looking to pursue a lien claim to kind of get your spot, you know, if they're, to put pressure on them to start to come to the table to at least negotiate and provide you the information you need to get you at least paid something. So that's my thoughts on it.
Julie, Chad, anything from the transactional perspective? I know we talked about, you know, when we had our first call, initial term, and what is that?
I have a few thoughts on this one. As far as the initial term, I think that's just ambiguous. I mean, to say the first anniversary of the initial term, I mean, I think I know what they mean there, but a term is a period of time. So I think it would be more clear to say the first anniversary of the commencement date or the effective date of the lease. To me, it seems here that the deal on the commission was made up front and it was just being paid in 2 installments, 50% on the front end, 50% after a year. So if I were the broker, I would argue that we already agreed on the amount and that it was owed. It's just owed in these 2 installments. So it shouldn't be dependent on whether the tenant is paying rent or not. I think to be even more clear, it would have been good, you know, to say that the payment of the second piece of the commission is not dependent on whether rent is being paid or if it's being paid in full. And I think the best thing for this broker would have been to just be able to collect it all up front. So I think anytime you can collect the full commission up front and not pay and not have it paid in installments or not paid on a monthly basis or something, that would always be ideal.
Yeah, I think that's all correct. And one thing I thought would be worthwhile to discuss just from a sort of relationship, business, practical standpoint, not necessarily a legal standpoint, is whether brokers to quote, you know, share in the pain over these last couple of months in terms of rent being deferred, being waived, and therefore being deferred and or waived, because drafted dozens of lease amendments, I think, in the last 3 or 4 months, where we have done a million different combinations of waiving rent, deferring rent, all that good stuff, looking at gross sales to see when you start. And I'm just asking the landlord to bear some of that burden. And our landlord / borrower clients, we're going to our lenders and asking them obviously to forbear and defer some loan payments and sharing that pain also. I'm just curious if the agents and brokers are asked to do that. And I think what Julie and Remy and Mike have all said is correct from a legal standpoint, and you know how to structure your agreements. I really don't like it when the landlord doesn't reach out to you first, but I'm just curious that from a relationship standpoint, you know, whether you can talk to the landlord and say, okay, you know, push some of my commission, but rent getting, you know, I want to see what agreements you've made with the tenant. I want to know when you've agreed to accept that deferred or delayed rent, all that stuff, so that then you can structure as an agent, you can agree how to structure a deferral of your commission as much as possible on what the tenant is going to be doing and when they're going to be paying their deferred rent. And again, you can sue everybody, and even if you have the legal right, but from a business standpoint, you know, you just have to sort of consider whether it makes sense to do that or whether it makes sense to join hands with everybody and try to, you know, just try to get through this as best as you can and swallow a little bit and get your commission deferred.
All right, thanks, Chad. Your audio kind of went in and out there. So I think what Chad was probably, and y'all probably got it, was that relationships in your business mean a lot. And it's sometimes you just have to make a business decision and try to figure out, is it worth it? Especially these days. So Julie, Remy, Michael, anything else on this particular one?
I wanted to, Remy mentioned 2 litigation aspects that I wanted to clear up for a second. One was liens, and there's a broker's lien statute, but I think that that's going to be a broader topic for another day because that can be a whole separate discussion. But another that he mentioned that I think can be very powerful and important for brokers to know about is the open account statute. And Louisiana allows certain open accounts, if you send a demand that sets forth the exact amount owed, if you send it and 30 days pass without getting paid on that open account, then you can sue to recover your attorney's fees as well as the actual amount that's owed. And that can actually be very helpful in terms of making a business decision about whether to litigate. And so to Remy's point about you got your 50% that's due at the first anniversary of the initial term, if you wanted to, as soon as it's due and you're getting some pushback, you can send that demand. It could help, you know, be the squeaky wheel to start opening up a discussion about whether they're going to pay and move forward.
Right. Just, you don't have to go to a lawyer just because you want to sue. They're helpful in working other things out, and sometimes just a letter on letterhead helps some. Let's see, any questions, comments, or any more discussion on this particular issue? All right, so Amy, let's move to the next one. All right, this is one that came up in some discussions with a legislator, more so with, she said she sees more people who've been practicing for a long time doing this. Actually, that's not this one, sorry. This is when, okay, I'm assisting current landlords with renegotiating their leases with tenants I secured for them prior to the pandemic. I am still owed last year's commissions on a few of them. How should I go about collecting these past due commissions? I will mute myself and y'all.
So I might take a stab at this one first. So this, I think, ties directly, again, to that open account idea that I was talking about. To the extent you can't work it out on just a business relationship end where you talked with them and they're still not paying, then you can come talk to a law firm. They can send a demand letter. They can set forth the exact amount that's owed. And then you might be able to, even just by sending the demand, be able to clear the way to getting that commission. So, and then if that fails, then you have the option to litigate. If you've done your demand correctly, you can again file suit under the open account statute and get your attorney's fees, as well as just suing for just a general breach of contract, saying that you were owed the amount.
And I would say another thought possibly to do, I mean, and this goes to kind of the spirit of what Chad was talking about before, due to the certain times. I mean, maybe you're willing to have a little good faith and goodwill to want to accept a little bit of the pain and the slow up of cash and payments on this thing. Good thing to do if you're willing to put a whole new lease in place, or you're kind of redoing a deal where your commission was tied to. I mean, you could get them to, and this is just me kind of thinking out loud, sign a promissory note for what they owe you and agreeing to stipulate to what those terms are of what it will be, when they will pay you back what it is owed. But I mean, they acknowledge the debt, they sign a new note, and this really goes, and this is kind of skipping all the way to your lightning rod section. But the prescriptive period for a past due note, if you let it sit out there, versus the prescriptive period on a commission, is my appreciation 2 more years. Although, I mean, obviously, like Michael said, if you start to pursue litigation, you kind of suspend, that prescription, and regardless of which one you're going to do, so you wouldn't let it expire under either scenario. But I would at least maybe get them to possibly execute a promissory note. So I'm curious to see what Chad and Julie may say about that.
Yeah, I agree with Remy, just at least that you would want to get comfortable, that there is an agreement on what is owed to you before you continue to work with the landlord on renegotiating leases. So I think whether it's by promissory note or just some kind of acknowledgement that they're going to pay, and ideally that it actually gets paid before you move much further in working with them. And I think as far as collecting what's owed to you, I agree with what Michael said. I think, when determining what legal action, if any, you should take, I think you just need to, take it on a case-by-case basis and consider the amount that's owed, the relationship that you have with that owner, and then also just your reputation. Do you want to make a big fight out of it if not that much is owed, or you just kind of have to think about those 3 factors in determining what to do. And I think the first step, like Michael said, is just talking with the landlord, and then if you want to go further, consult with an attorney and possibly have the attorney send a demand letter, which isn't that expensive or shouldn't be that expensive usually. And then further legal action could get more expensive. And again, it just depends on the amount owed, I think, whether you do that or not.
All right, any questions, comments, further discussion on scenario 4? Okay, then Amy will move on to 5. Okay, I am owed a monthly commission based on the agreed upon monthly rate for securing a 2-year tenant in a commercial property. When the pandemic hit, the landlord and tenant agreed upon a reduction in rent without my knowledge, and the landlord unilaterally reduced my commission. Whoever wants to take this one first.
I can.
I'll volunteer. Chad?
Hope I don't have mic issues. You know, I think, again, it goes back to what does the phrase agreed upon mean? And I think it's got to be clear in the agreement, the commission agreement, that the phrase agreed upon rate at the outset of the lease. If the agreed upon rate between landlord and later, that shouldn't affect. Remy pointed out earlier, that's why it makes sense to have a separate commission agreement separate from the lease, right? So that it's very clear what the commission is based on. So that phrase agreed upon should mean agreed upon rate of blank dollars per square foot, $12, $8, $15 per square foot. That's what the agreed upon rate is, and not leave it up to, well, the agreed upon rate is now 4. So that's what your commission is based on. Rate was $8 a square foot or $12 a square foot per when you executed the commission agreement, and that's what it's on any future economic circumstances.
All right, thanks, Chad. Remy, Julie, Michael, anything to add?
I think this one.
Go ahead, Julie.
Go ahead. Okay, I was going to say, I think this one, the way it's stated here anyway, is kind of ambiguous, whether it's the rate that was in effect when the contract was signed, or, you know, if there's a reduction in rent, then is the commission based on the then current rate or the initial rate? So I think the best practice would be to be clear on the front end, whether the monthly commission is based on the then current rate or the initial rate that was in effect at the start of the lease. If it is ambiguous, then I think it's just going to be a negotiation between the landlord and the broker. And I think in that negotiation, you know, the broker, again, just needs to consider the relationship with the landlord, the, you know, the pandemic, if that's, you know, like the case now, and maybe the broker needs to give in a little bit because that's what everyone's, you know, having to do to make things work. So, you know, I think it's just case by case basis, but here I think it's ambiguous.
Okay, and Julie, what would you recommend someone in this situation do, and what timelines would they have to do something in if they ultimately found they had to pursue litigation?
Well, I think what I would recommend them do if they found themselves in this situation now, kind of on the back end, is again, work with the landlord, the owner, and see, you know, what they can work out. I mean, it sounds like the owner would probably be willing to pay the reduced commission based on the reduced rental rate, and maybe that's all that the broker would be able to get at this point. If it's, again, on the front end and you're able to prevent this ambiguity, then, you know, just make clear in the contract that the commission is based on the then current or the initial rate that's in place at the start of the lease. The landlord may still ask the broker to take a reduced commission, but I think the broker would at least have an argument for the higher commission if the broker chose to make the argument. Again, I think that would be based on whether they want to risk the relationship and their reputation to do that. As far as the timeline, if they wanted to try to enforce the commission that's owed, I mean, you know, obviously you could probably talk to the landlord pretty quickly. A demand letter from an attorney, you know, should take a few days. I mean, if the attorney can get it out that quickly, but that doesn't take long at all for an attorney to draft. Litigation, Michael can speak better to that, but litigation can go on for a long time and get very expensive.
Michael, how about from your perspective, if somebody came to you and tried the demand letter, tried to work it out, and wanted to potentially pursue litigation, what would you do from there?
Right, well, that's, if you try the demand letter and you want to pursue litigation, then what you would do is draft a petition suing again, hopefully under the open account statute to secure that right to hopefully recover attorney's fees, but certainly under a breach of contract claim. But to everybody's, I guess, point, and to really emphasize, clarity up front is critical, especially in this context, because when a court gets an ambiguous contract, they're going to have to look at outside evidence and try to resolve what the parties intended when they crafted the agreement. And on something like this, I mean, to Julie's point, both sides are going to have pretty strong arguments, pretty compelling arguments about what the landlord's going to say. I really didn't intend that my future payouts wouldn't change if the rent went really far down. And then the broker is going to respond, well, I didn't expect you to be able to go out and just unilaterally lower my commission. And so to the extent that any of that can be headed off at the pass, where you're really clear up front as to what that commission is tied to, that is very important, especially in a situation like this.
I think that's exactly right. And what the effect of that is that, you know, your 5-page commission agreement becomes a 15-page. Wants that, and even lawyers don't want that. But, you know, explain to the other side that, you know, hey, look, this is going to save us all a bunch of money if we know from day one what the deal is and what the transaction is between the two of us. So.
Okay, Chad, you kind of went in and out there, and I think your point was that, you know, you don't want this long commission agreement, but if you can talk to the other side and say, we're doing this to prevent problems and expenses on the back end, everybody should try to do that. Michael, can you touch on like timelines, more prescription periods? Because you have this situation and, you know, people, I think, want to give people the benefit of the doubt and give them as much time as they can to make things right, get things right, but you do have a limited time to assert your legal rights.
Sure. Best practice in Louisiana is always to try to file any suit that you are going to file within a year, because there's a distinction between tort claims and contract claims. Tort claims are basically duties owed by law, and so you can still have actually a tort claim even in a breach of contract context, but tort claims have to be brought within a year of actually incurring the damage. Contract claims are much longer. Generally speaking, those are 10 years. So even if you don't file within a year, you still have some more time. But as I said, best practice is definitely to file within a year.
And we had the comment, if a landlord is not paying in full at the beginning of a lease, would you suggest preparing commission payment agreements that spell out payment terms, which is then signed by the broker and the landlord?
All right. Okay. Unless there's any questions about this one, we'll move on to the next scenario, Amy. Okay, this is the one the legislator talked to me about. So that they see a lot coming up with occupancy clauses and occupancy clauses not being fulfilled, and what do we do? But in this one, we tweaked it a little bit. The broker negotiates leases on behalf of the owner of a strip mall where commission is paid on an annual basis at 3% per year. There are no other terms regarding the commission. However, there's an occupancy clause in the lease whereby the tenant only pays half the rent if the mall is not full. COVID hits and 2 tenants move out with 6 months left on their leases. What do you do?
I think this is the same situation of where what does agreed upon rent or the basis for your commission mean. This scenario here, landlord has a better defense that, well, it's 3% of this reduced rent because you agent, you saw the lease, you knew this was that a co-tenancy condition reduced rent. It's not the scenario before of, well, we just went ahead, landlord and tenant, the two of us, and reduced the rent. This is a stipulated potential scenario. If certain conditions happen, the rent rather was going to be reduced. Is based on that. The agent wants to hear, and therefore it makes sense to put in the agreement that it's 3% of the original rate, not ever counting for a reduction based on any co-tenancy failure or anything like that. So again, it's just you're going to add you're going to 10 words to every sentence and make sure that every potential or contingency that you can think of at least is satisfied. But I think in this scenario, the landlord has a better argument that the commission should be reduced.
Yeah, I agree with Chad. I think it depends in part too on where this agreement with the broker is. If the broker had a separate agreement with the landlord and a commission agreement or listing agreement that said the broker would be paid 3% per year, but there was nothing about this, if the tenant only pays half, or if the mall is not full, the tenant only has to pay half, and so it's not tied to that, then maybe the broker has a better argument that it's based on the initial rent stated in the lease. But I agree with Chad, though, that because the lease is clear that the tenant, on the front end, the lease says that the tenant only has to pay half if the mall is not full, then there's probably a good argument on the owner's part that it only owes, it owes a lesser commission based on the lower rent.
And one thing I'll add on this one, when I was looking at it, I didn't know if this was maybe a scenario where there was just really a blanket agreement in place where we're going to negotiate leases for you for your property, your mall, and we're just going to continually collect 3% of whatever the annual rents are. Almost like if it's under management or something like that, it's just some kind of flat fee. So to Chad and Julie's point, would be curious what the exact nature of the agreement says. Because if it's what I'm interpreting it to be, I mean, to me, then it's whatever the landlord collects, regardless of what happens in any of these leases. If we're saying, hey, if your occupancy is X and your annual rental is X, and I get 3%, well, it's whatever you collect, I get 3%. If that's the case, then I think then there is no, you're going to share in whatever the reduction in rent is your proportionate share. But if this is a specific agreement for this lease, I think it's some of the other things that Julie and Chad had shared would come into play. So, to me, it would depend on what this agreement actually is.
We do have a question that came through the chat. Let me see here. It says, it's Scott Graff. Most often we see commission language that says we are to be paid on the scheduled gross rents. Does that protect us from being paid a reduced commission because the LL negotiates reduced rent during pandemic, being that the reduced amount is not what was originally scheduled? And I think y'all can all see that question on your chat box too.
Yeah, I think you have a better argument if it has language like that, the scheduled rents. I would be even more clear if you could, that it's, the rent in effect on the date of the lease. And then, often there are scheduled increases in rent. So, maybe that's why it says scheduled, but at least the rent that's in effect and that's planned on the date of the lease. So I think you'd have a good argument with that language. Yes, that if the rent were reduced just because of some separate later, negotiation between the landlord and tenant because of the pandemic or whatever, that the broker would have a good argument to be entitled to the higher commission.
Okay, Scott, does that answer your question? You want to unmute and discuss, or are you good?
That answers it. Thank you.
Okay, great.
And I would add, I mean, hindsight's 2020 on all this, and looking at these scenarios. The thing that jumps out to me is, wow, should the agreement state, and we curious if Chad and Julie and Michael have similar thoughts. Shouldn't it just state, hey, even if you go and amend or modify or whatever you do to your lease post signing of this commission agreement and signing of this lease, I am due this commission, on this formula, it shall not be reduced by any actions or amendments to your lease at all. So, I mean, that seems pretty much would be a stronger position in any case of how you word it, but would love to hear the other thoughts on it.
Yeah, I agree, Remy. And I think a lot of brokers may be pushing for that language in their agreements and leases. Of course, I think owners who, may have the stronger negotiating position often will definitely push back on that. And we'll probably push, for the other side of that if the rent goes down for whatever reason, that the commission would likewise be based on that then current rent.
Yeah, in full disclosure, I don't represent a lot of brokers. I probably would push back on that.
Yeah.
Kim, I have a question. This is David Gleason. Can you hear me?
Yeah, go ahead, David.
Okay. And guys, I've been in the business about 15 years. I've never had to go to a lawsuit, but involved in my first one. We had a client we represented that we listed a building in another small city close to Lafayette. The owner decided to negotiate a lease with a tenant. It was a 5-year lease deal. And in the lease, we put that if the building was sold to the tenant, that we'd get paid a commission on the sales price at 6%. This was a great client. He also refused to pay us up front. He demanded that every year we go and get the commission from him. So for the first 3 years, we had to go to his house and pick up the commission check. On year 4, he refused to pay and finally admitted that he had sold the building. And he stated that he canceled the lease agreement we had in place. So therefore, he didn't owe us because that lease was no longer valid. Anyways, we are now in the middle of pursuing this. And my question is, because I've never in 15 years had to pursue this, how far do you take this and are we going to have to pay all our attorney's fees? It does have a provision in the listing agreement that says that the person, I guess if we have to take it through the attorneys, that they'll be responsible for the fees. I'm just wondering in most scenarios how that plays out. Will we be able to get him to cover our cost because we've got 2 pieces of paper that say that he owes us? Just wondering what's typical.
So I can, I guess, weigh in on that a little bit. And it sounds like it's already in litigation. So you've already consulted with a lawyer and they've given you excellent advice, I'm sure. But in a perfect world, the answer to that is that if you have a prevailing party attorney's fee provision in a contract and you are entitled to an amount under the contract, then you would get both the amount plus your attorney's fees. So that's the short answer to that. The long answer is that people come up with all kinds of defenses, and oftentimes, most of the time, it goes to settlement, where there's some kind of haircut, and that's just the pragmatic ultimate end result. But in terms of a straightforward legal application, the way it should work is that you get the amount that you're owed plus your attorney's fees under the scenario that you just described.
And Michael, you're absolutely right. That's where we're at right now. Is their attorney is trying to settle with our attorney. And it's funny because he said that, he found some arguments, but yet they want to know if we'd settle. Of course, they came back with something way less than what we would accept. So we're going back to them with a little bit of a haircut. But anyways, just seems, in my mind, it seems unfair because if you got to fight to get them to pay you, why should you have to give in due to the fact that, you're going to have the expense of the attorney's fees? So that's why I was asking the question.
Yeah, and David, I think that's where you just have to make that business decision and the relationships and your reputation and everything else all has to factor into that. And that's the benefit of a good attorney. And they'll work through all that and weigh all of that with you, which I'm sure all the attorneys on this would do. And I'm sure yours is doing too. You don't want to spend good money going after bad.
Yeah, and I wasn't the broker at the time. It was another broker. So that other broker hired the counsel to go after him. So
And one other thing to add to that too, that Kim, I think kind of touched on just a moment ago, and that was the idea about whether it's collectible in the long run too. Know who you're suing and whether at the end of the day, there's going to be some amount of assets that you can actually collect against, because a judgment with no assets doesn't really do much good for anybody.
Yeah, this guy's one of my neighbors too, so it should be fun.
Okay, does anybody have any other comments on this scenario or any other general questions? If not, Amy, we'll move on. I think we have our lightning round.
Hey, Kim, this is Matt. Is there anything that LR would do to help David with his case or anything? Could you?
David, we can certainly visit about it after the call. It would just depend on the scenario, if it would have a impact to the real estate industry as a whole statewide, if it would set precedent that other cases would then have to follow. There's lots of factors that would go into that decision. So David, just give me a call later, okay? All right, so lightning round. Well, first, what's the statute of limitations on pursuing a commission? We've touched on this some, but if y'all could just go, I think it's what, 1, 3, 10 with different things, you know, like Michael talked about, you probably want to get it within 1, but if you don't, what happens? And what arguments do you have?
Right, 1, 3, 10, I think is the right answer to that. And 1, again, the 1-year anniversary is when you lose your tort claims, and those can be important for a number of different reasons. One is getting, for example, interest when it's not in the listing agreement, which I see as the next question. But so tort claims within 1 year, I believe it's 3 for promissory notes after that, and then 10 for regular contract claims. So all is not lost if you miss the first anniversary, but best practice is to try to bring it within 1 year.
All right, we'll hit the next one. When can you start adding interest to your commission, assuming there's an interest clause in the listing agreement?
Well, besides what legal interest might be owed under the statute, you can put in your contract at whatever your default rate, 12%, whatever it might be, just provide contractually that default rate will start running 5 days, 10 days after the date that it's due, starting with the date that it's due, and the landlord, and then you've got a contractual interest claim and not a statutory interest claim. Mike might speak more to when the statutory interest kicks in. I don't know if you need a jump or what before that.
Yeah, Michael, you want to hit that a little bit?
About statutory interest?
Right.
So generally speaking, the statute that I'm thinking about with respect to interest is with tort claims, and it's from the date of judicial demand. So that's the day that you've actually made a demand for the amount that's owed under a tort claim. So that's a key distinction there between with contract claims. In this particular scenario, like I said, has that you're assuming that it's in the listing agreement. So you would look, I think, to the terms of the agreement to determine when interest is, what the amount is and when it starts to accrue.
All right, then we'll move on to our last one, which is there a dollar amount where it is not worth pursuing a commission? So, and I don't know if this is a legal advice or a practice.
I would like to hear from Michael's experience with them. I don't do litigation. I always try to avoid it. To me, the numbers add up quick. And then also your business relationships. But when you're pursuing things, I guess there's potentials of putting things in collections, doing open account claims through your attorney, like Mike's talking. So, if you're putting the risk and exposure onto an attorney, and there's no cost to you, I guess it's worth whatever you think the relationship or business is. If it's one that you're never going to pursue again, or you don't think it's going to professionally be damaging to you, then I guess no dollar is worth not chasing. But I'm sure practically speaking, each person has a relative threshold on when they're willing to write something off.
Yeah, I would just add, I think it's a business decision that the broker would have to consider just on a case-by-case basis. And like we've said, I think a demand letter can be very effective and cost efficient. I also think that, if the broker is unsure about whether they want to pursue any kind of legal remedy, then just talking with a good lawyer, the lawyer will let you know, depending on the merits of the claim and the amount of the claim, whether it's worth pursuing or not. So I think if there's a question, then always good to just look into it.
All right, that concludes our lightning round. Does anybody have any other questions, comments, scenarios they'd like to talk to our panel about? If not, like on behalf of Flo Meadows, Flo, do you want to unmute yourself and maybe close us out? I know we didn't plan on that, but you put some nice comments in the chat box. Okay. Well, I hope everybody's, oh, go ahead, Flo. I'm sorry.
I'm muted if you would like to say anything. And I've just posted up an upcoming list of chapter events for everybody to reference as well.
Wonderful. Absolute thank you, Kim, for all that you've done to facilitate today. Matt Eaton, Scott Graff for arranging this for our chapter. Very pleased to see the participation today and delighted to see Barry Spicer with us, a former Institute president for whom we have a named scholarship. We always appreciate having that type of participation from past leadership. So thank you, Barry, for being here. But thank you to each one of the panelists. We know how much time it takes away from your day to be with us here today. Very much appreciate your guidance and insights. Thank you kindly.
Thank you, Flo. And these are 4 great attorneys we have with us. So if they're in your market or not, give them a call. I know they do good work. And if maybe they don't not in your area or not in your expertise, I'm sure they could refer you to somebody that could help you also. We appreciate them.
Thanks, Kim.
All right, Amy.